So the Waldman statements. So let's go down to the Waldman statement. So the first Waldman statement was quoted in the Daily Mail article and stated that Ms. Heard used fake sexual violence allegations and promoted sexual violence hoaxes. The jury did not find this to be defamatory. So they did not find that to be defamatory. So we're just going to toss that statement out. The second statement stated that Ms. Heard's allegation were a hoax. That included a quote from Ms. Heard's attorneys that we believe Amber and we believe in Amber. The jury did not find this one to be defamatory either. But the last statement, this is the sole statement that they found problematic, was the one that that was found in the Daily Mail, April 27th, 2020, and says, exclusive, I need to report an assault. Listen to the 911 call made the night Johnny Depp and Miss Amber Heard had a blowout fight that ended their toxic 18th month marriage. But both claim tape backs up their version of the events. There's a description of the call to the police, a date on which Miss Heard alleged Mr. Depp threw her phone at her and roughed up their apartment at the Eastern Columbia building. That's the wine that was spilled on the floor. We all know, by the way, that wine was spilled not by Johnny. And I'll just leave it at that, right? I'll just leave it at that. That wine was not spilled by Johnny. And I'm not going to say who did it, but that was not Johnny. That was definitely not Johnny. So the article comments that Heard's attorney says phone records and police logs vindicate Heard's account of the final shocking episode of domestic violence she endured before filing for divorce. Depp's legal team says this recording does the precise opposite, however, by raising discrepancies, yes, in the various accounts Heard and her allies have given of the notorious dust-up. Clearly, nobody believed this shit because their stories were inconsistent. We all heard that. The stories that they gave about what happened that night didn't match up, and they didn't match up with what the police saw. When the police walked in, the scene was a lot different than the photos. What they were saying was a lot different than the photos. Reality did not match up at all. At all. So here's the purportedly defamatory statement. Here it is. This is the money shot, guys. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The cops came to the penthouse, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, then placed a second call to 911. Okay, let's be real. I'm going to break down where Waldman kind of fucked up on this one, because I'm going to be honest. I'm going to say where he fucked up. So here's where he fucked up. He fucked up by saying this last part, because we don't know this. We don't know for a fact this is how this went down. And it's impossible for us to know this is for a fact how this went down. So the statement that I think is got him in trouble is, so Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. Well, it's hard to know whether they were working under direction of a lawyer. I don't know if they have any proof of that they were working under direction of a lawyer and a publicist. They might have been. We don't know that for sure. And it's saying Amber and her friends. Okay, well, did her friends help, or did she do it alone? Did somebody do it? One of her friends do it for her? Remember this. Amber Heard had a lot of simps. God only knows. It could have been Elon going over and messing it up. It could have been James Franco. Maybe they were doing the three-way. Maybe they were doing the devil's triangle. You had Elon and James Franco pulling the Eiffel Tower move, and the wine bottle got knocked over. We have no clue. So I think he shouldn't have speculated specifics. I think if he'd just been general, like this is not exactly how it went down, and that's all he said. Just like the event that Amber put out doesn't line up with the testimony and the facts and the police reports. If he said that, I don't think they'd be in trouble at all. But I think because they added this detail that was unnecessary, that's how they got them in defamatory territory. That's how Waldman got into defamatory territory. But I still don't think it meets the malice standard. I think you could get to simple defamation, but certainly not malice, because there's no way to actually prove that he knew this was for a fact false. In fact, I think that Johnny may have speculated this, but there's no way to know whether that was for a fact false, because we don't have anything that conclusively rebuts this. So listen, I think this should be thrown out, but I'm just telling you, hey, if you make statements, be a little careful. Be a little careful. But that being said, let's go down to the actual legal arguments. Here you go. The evidence related to the Waldman statements. Let's talk about that. So Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making any one of these three statements. There you go. There was no evidence that Johnny Depp directed them to make the statements. Indeed, Mr. Depp testified that he had never even seen the Waldman statements prior to filing of the counterclaim. So let's go over this again. He did not see the statements. Waldman made them on his own. And yes, there's agent principle, okay? Thank you for bringing that up in the Rumble chat. And Lumberman, welcome to Rumble. This is new subscriber. I am a YouTube sub to your other channel. Screw YouTube. Good job, Andrew. Enjoy your channel. Fuck yeah, man. Fuck yeah. I appreciate based lumbermen. Based lumbermen are always cool. Don't want the commie lumbermen, just the based ones. But yeah, in terms of principal agent, which some of y'all brought up over there on, I think Mike brought that up over on Rumble. This is what breaks that. When you have no direction and no proof of direction, you break principal agent. Mr. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services. He was retained and still represented him at the time of his trial testimony, but Depp is not his only client. Mr. Waldman's relationship is solely one of attorney-client. This is all establishing that he is an independent contractor. He is not an employee of Johnny Depp. And guys, if you don't know, there's a big difference between employee and independent contractor. If you are solely captured by one employer, you are an employee. Even if you are making some money elsewhere, let's say like a little bit of money elsewhere. Let's say you work for one company remotely, right? Let's say you work for Google and you're, a big cuck. So you're working for Google and they're paying you $300,000 a year. But you also like to, kick it up at night. Maybe you like to bartend. So you bartend one night because you think it's fun. You just want to do it on maybe a Saturday night. You want to bartend. Helps you meet some ladies or maybe some dudes. Who knows? It's 2022. Maybe you're meeting something in between. Maybe like a Keffels or two. Who knows? No judgment. No judgment. As long as you stay away from the fucking children. That's all I'm saying. And you do that for like one night. You make maybe a couple $100. That pales in comparison to $300,000. You're still an employee of Google. You're not an independent contractor. You're captured by them. But that's not true for Mr. Waldman. Waldman has multiple clients. So he is not an employee. He's an independent contractor. So here's the argument. The court fucked up. They erred in denying Mr. Depp's motion for summary judgment and a motion to strike the evidence. I agree. They should have struck it before. They shouldn't have let it go to the jury. There was no legal basis for them to enter into that finding, to enter into those claims regarding Waldman. All the Waldman stuff should have been thrown out. I think they were afraid, and this is the thing I think I was yelling about during the trial. They were afraid of throwing out her claims because they thought on appeal she might win. And I think the judge wanted it to stick. I really do. I really think that judge wanted this to stick because they did not want that shit to come back. Just ask Anante. I think she wanted this to stick. But I think that Johnny can win this appeal point because I do believe at trial this should have gone in Johnny's favor. And it says right here, they must consider that they must independently decide whether the evidence in the record appeal is sufficient to support a finding of actual malice by clear and convincing proof. We had no proof. Clear and convincing is not beyond a reasonable doubt, by the way. This is a civil trial. It's a civil trial. But clear and convincing still requires some fucking proof. What's up, Jim? Jim in YouTube. Shout out to Jim. He's a longtime supporter. Love Jim. Based as fuck. Says, what's up, Andrew? For the record, you are my employee, and I take responsibility for all your actions. Jim, I'm going to need to see a paycheck from you, or at least a super chat receipt, because listen, I'm Mike right now. Mike Morrison is my employer. So he's the top employer of the day. So all hail Mike Morrison. R.I.P. Jim Satala and Andrew Esquire Co. It is R.I.P. Is Attorney Tom in the chat? Can anybody see Attorney Tom? Is he bugging your ankles? If he's bothering you, just step on him. He likes it. He gets off on it. He's gonna start selling his like used panties in a vending machine at Anime Matsuri after he's been stepped on. So, whether an alleged defamatory statement is an actionable statement of fact or a non-actionable opinion is a matter of law to be determined by the court and is determined de novo. Under most circumstances, whether a person is an employee is generally a question of fact for the jury. However, the evidence admits of only one conclusion. There is a matter of law that is de novo. So yeah, there's no actual evidence. And if the court can look at it and say the evidence hasn't been provided, that's a matter of law. They say there's nothing there. So as a matter of law, there's nothing for you to decide by clear and convincing evidence. You haven't presented anything for the jury to decide upon. That is a legal issue. That is a legal issue. Oh, and shout out to Ken. Ken wants me on his show. I told him I'm pretty busy this month, but maybe in December or January, I'll go on Ken's degenerate casting couch or counseling couch or whatever the guy calls it. Guys, by the way, make sure you're smashing that pussy. Make sure you're out there smashing that pussy on Rumble. I really appreciate it. All of you. I think we got it. We got still about 500 over there on Rumble, and we've got 278 pussy smashes. So I do appreciate that. And over on YouTube, always appreciate you guys smashing the like button as well. So in the context of vicarious liability, Virginia has long recognized the distinction between servants and independent contractors. Now, guys, don't get excited. I know it's Virginia. Servants does not refer to shit that's going on before 1865 in Virginia. Servants means employees. Servants mean employees. Oh, and based on my face, you said in your first live video, you said you'd come on as my first guest. I hope you keep your word, brother. I'm going to make a YouTube channel. Thank you for motivating me. No, awesome. Yeah. Give me a message. Shoot me a message. Shoot me when you're going to do it. Obviously, my time is limited. I'll do my best to be amongst the first, right? Amongst the first on your channel. Happy to stop in. Shoot me an email. Tell me that your handle, that you are based on the face or based on my face, and I will. I'll show up, man, because I want to support you guys. I want to support your small content creators, and I want to help make you big. Look at Legal Vices, right? I had to talk that motherfucker into getting on YouTube. He was not about it, right? And now he's fucking killing it. This guy is killing it. So I want to help you guys kill it and make good content, because unlike some other motherfuckers in this space, unlike some people with small PP energy, I don't have a scarcity mindset. I don't believe that anybody is stealing from anybody, anybody's copying from anybody. I don't believe there's too many people. No, there can be more. We can make each other better. If there's competition, I say fucking bring it. I ain't scared. Shut Up and Cook says, vote Zeldin in New York. I am telling Nick on all the chat misbehaving. Yes, feel free to rat everybody out to Nick. Nick is a bit of a tattletale, I will say. So the law on servants and independent contractors, employees and independent contractors, is generally that a principal is not liable for the tortious conduct of an independent contractor. Let me say that one more time. An independent contractor who acts tortiously, that doesn't come back on the employer, or rather the person who's paying them. They're not an employer. They're not a servant. So the independent contractor, stop text messaging me over here. The independent contractor is not going to have their stuff blow back, because guess what? They've got multiple clients. They're not doing it under the direction of one person. They have many people telling them what to do. The doctrine of respondeat superior imposes tort liability on an employer for the negligent acts of its employees, i.e. its servants, but not for the negligent acts of an independent contractor. The theory unto which a master is held liable for his servant, once again, guys, we're not talking about anything that was going on before 1865. We're talking about, like, when we say master and servant, it is employee and employer. It's meant that somebody, and when they say it, they're using it for emphasis, that there's a strong control that an employer has over an employee. And I will say this, guys, I'm an independent contractor. I work for several in my legal job. Yes, I am still a lawyer. I have several people I work for. None of them is my master. None of them is my master. I can tell all of them to go fuck themselves. And in fact, sometimes I do. And I can also take on clients as I want to. The other day, I had a guy who just wanted a simple consent form done for some audio visual recording. I got that shit done in an hour. Sent the guy a bill, boom, bam, bum, bim, done. You know, you can do that when you're working for yourself. You don't have to be beholden to one person. Just like I'm not beholden to YouTube. I can say, fuck YouTube. Now I'm on Rumble. Now I'm on Locals. Now I'm on these other platforms. You don't want to be beholden to one master nowadays. It really is trouble, to say the least. Oh yeah, sorry. There was one, Locals didn't load here. There was one more Locals tip I need to read here. Royal Plague sent a $10 tip, which says, Farron can skip one of my 6 rants yesterday. Farron chose to skip one of my 6 rants yesterday. Apparently her favorite politician is LBJ. I unsubbed and canceled all my accounts on all platforms. No read, no money. You are still my third on my watch list. Hey, appreciate that. Appreciate that. Yeah, LBJ. Not my pick. Not my pick. Wow. Some of these memes, I wish I could show them. I will show this one though. This is a good one. This is a good one I can show from the Locals chat. This is a good one. This is definitely a good one. It's going to be more like sex for settlement money, but we'll see. We'll see. Let's see. All right. Let's continue here. So the servant's conduct is based on the right of the master actual potential to control that conduct and see how negligent acts which cause injury to others do not occur. If the relationship with them does not give the employer the power, then he should not be held responsible for the occurrence over which he had no control. One more time. If you don't have the power over it, if you don't direct it, then why are you responsible? If your mailman, maybe not your mailman. Let's do it this way. Let's say you order some Papa John's. You're paying the delivery driver, and the delivery driver ends up, I don't know, taking a shit in your neighbor's yard. You're not liable for the cleanup. That's not something that you have to do. Now, maybe Amber should have been liable for the bed cleanup. That's a whole separate story. But if somebody you pay to do something, your doctor, for example, your dentist, if your dentist ends up banging his secretaries and his, assistants, you didn't tell him to do that. You paid him to fix your cavity because you ate too many ho-hos like Nick Rekieta. Jesus Christ, Chunkata. But you didn't pay him to fuck his secretary, right? Or to sexually assault the secretary. Let's make it something bad, right? That you're not responsible for that. You came in for one thing, you got another. You didn't direct him to do that. You didn't say, hey, go do this thing. You said, no, do this one thing for me. This is what I'm telling you to do. Don't do the other thing. So the factors of the independent contractor are selection and engagement, payment of compensation, the power of dismissal, and the power to control the work. So they can't fully control the work. They can dismiss them at any time. That's true. That's another one. The payment, well, they're not being entirely paid by one client. And in selection and engagement, they say they're independent. And they haven't been able to establish at all proof that violates any one of those factors. And right here, this is the greatest one. And this is why this is such a fucking problem for attorneys if they let it stand. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. Boom. Boom. We have to deal with the goddamn Bar Association. We've got to deal with personal ethical rules. That's something an employee usually doesn't have to deal with. They just have to deal with whatever rules their job, makes up. And by the way, the job only makes up rules to cover their own ass. By the way, this is hilarious. Someone just sent me this meme. I gotta show this one. This is a good one. Let me give some credit. Who sent this one? My M Turch. So Gamen sent this one over here on Locals. This is a good one over on AOC. This is hilarious. Laughing my ass off at a billionaire earnestly trying to sell people on the idea that free speech is actually $8 a month subscription plan. Your feedback is appreciated. Now pay the goddamn $8. Now pay the $8. We'll be talking about Elon later and a little bit more about this AOC thing, but that's laughable. She has so much money. $8 is nothing. So yeah, well, the second point, which is great here, is there's no actual evidence of malice. They didn't actually show anything that Waldman did this intentionally because they can't be vicariously liable for their tort. There's no way to do this unless you prove there's intent. You have to act with actual malice, which is subjective knowledge that it was false or reckless disregard of whether it was false or not. You must demonstrate by clear and convincing evidence that the defendant realized his statement was false. Sorry. Guys, I'm still in this cough medicine. And I was getting a dry throat there. R.I.P. my throat. R.I.P. my throat. Especially if I'm yelling with Joe today. I'm going to be dead. Not going to lie. All right. So actual malice is measured by whether... Damn. A reasonably prudent man would have published or would have investigated before publishing. There's sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts of the truth of his publication. That's the standard. But there was no reason to doubt it. In fact, everything backed that up. By the way, thank you, Sherry. I am drinking water. This is water. It's like room temperature water. Disaster Master, I'll give you a summary at the end, but we're talking about the Depp appeal and Amber's appeal and how Johnny is going to destroy her on this first point. I think that he's got three arguments, but I think this first argument is the best. And I think the fact that these statements have never been shown to be malicious is damning. They did ask, this is a footnote, they did ask whether he relied upon information from Mr. Depp But Waldman didn't answer. He said it violated attorney-client privilege. So there's no ability to draw that inference. So therefore, in context, they're not, and this is the third argument, they're not actionable. Pure expressions of opinion, not amounting to fighting words, cannot form the basis of an action for defamation. I think this was an opinion. I don't think this is a provably false factual connotation. I don't think there's any proof that this was false. See, when viewed in context, it is a non-actionable opinion. Importantly, it is a statement by a lawyer in the context of litigation and necessary debate. Further, it was made to a reporter who presented both sides. So you had the other side that says, we believe Amber and we side with Amber. So they're saying we believe Johnny and side with Johnny. Should an attorney be punished for that? That's a horrible precedent. That's a fucking shit precedent. By the way, what people say, he didn't have this cough when he was before Japan. I was partying like a fucking rock star in Japan. That was probably the problem. Too much sake, too much vodka, too much beer, a lot of stuff. The problem is Max Mura and Meme Copium. Blame both of those guys. Blame both of those guys. So yeah, I don't think this is actionable. I don't think they can move on that. The jury instructions, smaller argument. Think that's kind of nullified. But they could prevail on that one. They could prevail on that one because they did prove that he's an independent contractor. And last but not least, the full context. So giving the full context of the article, of the full Daily Mail article, is something they did not do. They suppressed that. But look at what they did here, guys. Their conclusion is very tight here. It's reverse the judgment as to the counterclaim and otherwise affirm the judgment for Mr. Depp. This argument, his argument in general, is so tight. It's so put together that I don't think there's any way they can rebut this. I don't think there's any way they can lose on this one. They did what lawyers should do. When you make an argument, you should make it concisely and clearly, and they did that. He's an independent contractor, no actual malice, no proof. No proof. That's it. Biggest things. And the sub claims, the jury instruction claims, are related to the independent contractor instruction, which ties back in. He clearly is an independent contractor. And the last one is context, which, okay, maybe that doesn't always happen. Maybe you always want more context, but it's a good argument. So this is a solid brief. I think my money is on her claim getting nuked. I think it's almost got to be for the sake of attorneys out there. I think for the sake of attorneys, it's got to be nuked. So my verdict is, I think it's going to get nuked. We'll see if I'm wrong, but I'm putting my money out there. I'm putting my money where my mouth is. I make predictions. Sometimes they're bold. Sometimes I rock out with my cock out. But yeah, I think it's getting overturned. I think she's getting hit with a bigger one.